Welcome to Part 2, Freedoms of Religion, Privacy, and Criminal Due Process, Encouraging Community and Civic Engagement. Remember that the script and quiz are all together. The right to privacy. So far in this section, we have explored the relationship between the civil liberties and some key themes of this unit: civic participation, inclusiveness, community building, and community engagement. We now shift our focus somewhat to consider the right to privacy, the right of an individual to be left alone and to make decisions freely without the interference of others. Privacy is a core principle for most Americans, and the right to make decisions, especially about intimate or personal matters, is at the heart of this right. Yet the right to privacy is also necessary for genuine inclusiveness and community engagement, because it ensures that each individual is able to act autonomously and to make decisions about how he or she will interact with others. The right to privacy is highly controversial and the subject of many public debate. In large part, the reason is that this right is tied to some of the most divisive issues of our day, including abortion, aid in dying, and sexual orientation. The right to privacy is also controversial because, unlike the freedoms of speech, the press, assembly, and religion, it is not explicitly mentioned anywhere in the Constitution. A further reason for the debate surrounding the right to privacy is that the Supreme Court has only recently recognized it. For more than 100 years, Supreme Court justices and lower court judges have concluded that the right to privacy is implied in all other liberties spelled out in the Bill of Rights. Not until the landmark Supreme Court case of Griswold v. Connecticut, 1965, did the courts firmly establish the right to privacy. This issue in this case may seem strange to us today, whether the state of Connecticut had the power to prohibit married couples from using birth control. In their decision, the justices concluded that the state law violated the privacy right of married couples by preventing them from seeking to access birth control, and the court struck down the Connecticut prohibition. The court argued that the right to privacy was inherent in many of the other constitutional guarantees. Most importantly, the First Amendment freedom of association, the Third Amendment right to be free from the quartering of soldiers, and the Fourth Amendment right to be free from unreasonable searches and seizures. The Fifth Amendment protection against self-incrimination, and the Ninth Amendment assurance of rights not explicitly listed in the Bill of Rights. Justice William O. Douglas and his colleagues effectively argued that a zone of privacy surrounded every person in the United States, and the government could not pass laws that encroached upon this zone. In its ruling, the court asserted that the right to privacy existed quite apart from the law. It was implicit in the Bill of Rights and fundamental to the American system of law and justice. The right to privacy hinged in large part on the right of individuals to associate with one another, and specifically the right to marital partners to engage in intimate association. In a 1984 case, the Supreme Court ruled the Constitution protects two kinds of freedom of association. 1, intimate associations. 2, expressive associations. And that was Roberts versus the USJCs of 1984. The protection of intimate associations allows Americans to maintain intimate human relationships as part of their personal liberty. The protection of expression associations allows people to form associations with others and to practice their First Amendment freedoms of speech, assembly, petition, and religion. The challenge for the court since Griswold has been to determine which activities fall within the scope of the right to privacy. And that question has placed the justices at the center of some of the most controversial issues of the day. For example, the first attempt to extend the privacy right, which raised the question of whether the right to protected abortion, remains at least as controversial today as it was in 1973 when the court decided the first abortion rights case in Roe v. Wade. In Roe and the many abortion cases the court has heard since, the justices have tried to establish whether a woman's right to abortion takes precedence over any interests the state may have in either the woman's health or the fetus's life. Over time, the court has adopted a compromise position by rejecting the view that the right to abortion is absolute and by attempting to determine when states can regulate or even prohibit access to abortion. In 1992, the court established the undue burden test, which asks whether a state abortion law places a substantial obstacle in the path of a woman seeking an abortion before the fetus attains viability. Although the court used this standard to strike down spousal notification requirements, it has upheld other requirements imposed by some states, including waiting periods, mandatory counseling, and parental consent. The court has also stepped gingerly around other privacy rights, such as the right to choose one's sexual partners and the right to terminate medical treatment or engage in physician-assisted suicide. Both of these rights have been presented to the court as hinging on the much broader right to privacy. With respect to the right to terminate medical treatment, the court has been fairly clear. Various court decisions have confirmed that as long as an individual is competent to terminate treatment, the state may not stop him or her from taking this action, even if stopping treatment will lead to the person's death. The court has been less clear in its rulings when an incompetent person's rights is advanced by another individual, such as a spouse, a parent, or a child. In these circumstances, the court has accepted the state's argument that before treatment may be terminated, the state may require that the person seeking to end life show that his or her loved one would have wanted that course of action. When a person's wishes are not clear, loved ones may wage legal battles over whether to discontinue life support. If you remember back a couple chapters, we talked about Terry Schiavo and then also the case in Missouri. In cases involving the right to engage in consensual sexual activities with a partner of one's choosing, the Supreme Court has also employed a less than absolute approach. For many years, the court allowed states to criminalize homosexual activity, finding that the right to engage in consensual sexual activity did not extend to same-sex partners. In a 2003 case, Lawrence v. Texas, the court changed course by ruling that the right to engage in intimate sexual activity has protected as a liberty right, especially when the activity occurred inside one's home, and that states could not criminalize this activity. Since that decision, rights activists have worked through the courts and state federal legislatures to secure for some same-sex partners the same rights that heterosexual couples now enjoy, including benefits provided by group health insurance and marriage. Marriage is regulated by the states, and as you can see in this map, there is a wide range of laws, state laws pertaining to marriage, Many of these laws have only been recently passed. The Lawrence decision aside, states are still free to prohibit a range of sexual activities, including prostitution, child sex abuse, and sex in public places. In the court's view, these activities can be prohibited primarily because they are not consensual or do not take place in the home, a place that accords special protection by the privacy right. The right to privacy remains very controversial. Cases brought under the right to privacy tend to link this right with some other civil liberty, such as the protection against unreasonable search and seizure, the right to free speech, or the protection against self-incrimination. In other words, the privacy right, which the justices themselves created, seems to need buttressing by other rights that the Bill of Rights explicitly establishes. The explanation for this development may be the contentiousness of American civic discourse about abortion, aid in dying, and other privacy issues. In short, continuing civic disagreement may have forced the court to fall back on the rights that are well established and more widely accepted. Public discourse about privacy is constantly evolving as people voluntarily share more and more information about themselves through online networking sites such as Facebook, MySpace, Twitter, LinkedIn, Instagram. Users of such sites and bloggers share stories, photos, and videos of themselves, as well as of others who may be unaware that they are the subject of a posting, a blog, or a video. Civil libertarians worry about the misuse and theft of personal information in a high-tech society where people's financial, employment, consumer, legal, and personal histories are so easily accessible. Government and law enforcement agencies are still deciding how they may use each material in criminal investigations. Legal implications remain unclear. The last category of civil liberties that bear directly on civic engagement consists of the criminal due process protections established in the 4th, 5th, 6th, and 8th Amendments. Does it surprise you that that so many of the Bill of Rights amendments focus on the rights of individuals accused of crimes? The context of this emphasis is the founders' concerns with how the British monarchy had abused its power and used criminal law to impose its will on American colonists. The British government had used repeated trials, charges of treason, and imprisonment without bail to stifle political dissent. The founders therefore wanted to ensure that there were effective checks on the power of the federal government. especially in the creation and enforcement of criminal law. As we have seen, the Bill of Rights amendments were incorporated to apply to states and to their criminal codes through the process of selective incorporation. Thus, criminal due process protections are the constitutional limits imposed on law enforcement personnel. These four amendments together are known as the criminal due process rights because they establish the guidelines that the government must follow in investigating, bringing to trial, and punishing individuals who violate criminal law. Each amendment guides the government in administering some facet of law enforcement, and all are intended to ensure justice and fairness in the administration of the law. Criminal due process is essential to guarantee that individuals can participate in the larger society and that no one person is singled out for better or worse treatment under the law. Like the First Amendment, due process protects political speech and freedom. Without these liberties, government officials could selectively target those who disagree with the laws and policies they advocate. Moreover, without these rights, there would be little to stop the government from using criminal law to punish those who want to take action that is protected by the other amendments we have examined in this unit. For example, what good would it do to talk about the freedom of speech if the government could isolate or punish someone who spoke out critically against it without having to prove in a public venue that the speech threatened public safety or national security? The criminal due process protections are essential to ensuring meaningful participation and engagement in the larger community and to safeguarding justice and fairness. The Fourth Amendment requires police to get a warrant before engaging in a search and guides law enforcement personnel in conducting criminal investigations and in searching an individual's body or property. It has its roots in colonial history, specifically in the British government's abuse of its law enforcement powers to prosecute and punish American colonists suspected of being disloyal. The Fourth Amendment imposes significant limits on law enforcement in barring police from conducting any unreasonable searches and seizures. It requires that they show probable cause that a crime has been committed before they can obtain a search warrant. The warrant ensures that police officers can gather evidence only when they have probable cause. Further, a judicially created ruling known as the exclusionary rule compels law enforcers to carry out searches properly. Established for federal prosecutions in 1914, the exclusionary rule forbids the courts to admit illegally seized evidence during trial. This rule was extended to state court proceedings in the Supreme Court decision Mapp v. Ohio, 1961. In this case, the court overturned an Ohio court's conviction of Dalry Mapp for the possession of obscene materials. Police had found pornographic books in Mapp's apartment after searching it without a search warrant, and despite the defendant's refusal to let them in. Critics of the exclusionary rule note that securing a warrant is not always necessary or feasible, and that guilty people sometimes go free because of procedural technicalities. They argue that reasonable searches would not be defined solely by the presence of a court-ordered search warrant. What are reasonable and unreasonable searches under the Fourth Amendment? Over time, the U.S. Supreme Court has established criteria to guide both police officers and judges hearing cases. In the strictest definition of reasonableness, there is a warrant. Where there is no warrant, the search is considered to be unreasonable. However, the Supreme Court has ruled that even without a warrant, some searches would still be reasonable. In 1984, for example, the court held that illegally obtained evidence could be admitted at trial if law enforcers could prove that they would have obtained the evidence legally anyway. In another case that same year, the court created a good faith exception to the exclusionary rule by upholding the use of evidence obtained with a technically incorrect warrant, because the police officers had acted in good faith. More broadly, a warrantless search is valid if the person subjected to it has no reasonable expectation of privacy in the place or thing being searched. From colonial times to the present, the assumption has been that individuals have a reasonable expectation of privacy in their homes. Where there is no reasonable expectation of privacy, however, there can be no unreasonable search, and so the police are not required to get a warrant before conducting the search or surveillance. Since the 1990s, the court has expanded the situations in which there is no reasonable expectation of privacy and hence no need for a warrant. For example, there is no reasonable expectation of privacy in one's car, at least in those areas that are in plain view, such as the front and back seats. There is also no expectation of privacy in public places such as parks and stores, because it is reasonable to assume that a person knowingly exposes his or her activities to public view in those places. The same is true of one's trash. Because there is no reasonable expectation of privacy in the things that one discards, police may search this material without a warrant. In instances where there is a reasonable expectation of privacy, individuals or their property may be searched if law enforcement personnel acquire a warrant from a judge. To obtain a warrant, the police must provide the judge with evidence that establishes probable cause that a crime has been committed. Further, the warrant must be specific about the place to be searched and the materials that the agents are seeking. These requirements limit the ability of police simply to go on a fishing expedition to find some bit of incriminating evidence. As society changes, expectations of privacy change as well. For example, technological innovation has given us email and the internet, and Fourth Amendment law has had to adapt to these inventions. Is there a reasonable expectation of privacy in our communications on the internet? This is an important question, especially in light of citizens' heightened concerns about terrorism and white-collar crime. The Fifth and Sixth Amendments establish the rules for the conducting of a trial. These two amendments ensure that criminal defendants are protected at the formal stages of legal proceedings. Although less than 10% of all charges result in trials, these protections have significant symbolic and practical importance because they hold the state to a high standard whenever it attempts to use its significant power to prosecute a case against an individual. The Fifth Amendment bars double jeopardy and compelled self-incrimination. These safeguards mean, respectively, that a person may not be tried twice for the same crime or forced to testify against himself or herself when accused of a crime. These safeguards are meant to protect people from persecution, harassment, and forced confessions. A single criminal action, however, can lead to multiple trials if each trial is based on a separate offense. The Sixth Amendment establishes the rights to a speedy and public trial, to a trial by jury of one's peers, to information about the charges against oneself, to the confrontation of witnesses testifying against oneself, and to legal counsel. The protection of these Fifth and Sixth Amendment liberties is promoted by the Miranda rights, based on the Supreme Court decision in Miranda v. Arizona. In the Miranda case, the court outlined the requirement that prior to questioning, the person must be warned that he has a right to remain silent, that any statement he does make may be used against him, and that he has the right to the presence of an attorney, either retained or appointed. Later cases have created some exceptions to the Miranda rights. The last part of the Miranda rights with the ability to obtain counsel is from Gideon v. Wainwright. Together, the Fourth, Fifth, and Sixth Amendments ensure the protection of individuals against abuses of power by the state, and in doing so, they promote a view of justice that the community widely embraces. Because these rights extend to individuals charged with violating the community's standards of right and wrong, they promote a broad sense of inclusiveness, a respect even for persons who allegedly have committed serious offenses, and a desire to ensure that the justice system treats all people fairly. The court has considered the community's view in reaching its decisions in cases brought before it. For example, through a series of Supreme Court cases culminating with Gideon v. Wainwright, the justices interpreted the right to counsel to mean that the government must provide lawyers to individuals who are too poor to hire their own. The justices adopted this standard because they came to believe that the community's view of fundamental fairness dictated this result. Before this decision, states had to provide attorneys only in cases that could result in capital punishment. The meaning of cruel and unusual punishment has changed radically since the Eighth Amendment was ratified, especially with regard to the imposition of capital punishment, the death penalty. Moreover, Americans have always disagreed among themselves about the death penalty itself. Throughout the country's history, citizens and lawmakers have debated the morality of capital punishment as well as the circumstances under which the death penalty should be used. Central to the public debate have been the questions of which crimes should be punished by death and how capital punishment should be carried out. Generally, the court has supported the constitutionality of the death penalty. An exception was the landmark case Furman v. Georgia, 1972. We've talked about that case several times, in which, in a 5-4 decision, the court suspended the use of the death penalty. Justices Brennan and Marshall believed the death penalty to be incompatible with evolving standards of decency in contemporary society. The dissenting justices argued in turn that capital punishment had always been regarded as appropriate under the Anglo-American legal tradition for serious crimes, and that the Constitution implicitly authorized death penalty laws because the 14th Amendment referenced to the taking of life. The majority decision came about as a result of concurring opinions by Justices Stewart, White, and Douglas, who focused on the arbitrary nature with which death sentences had been imposed. The court's decision forced the states and the national legislature to rethink their statutes for capital offenses to ensure that the death penalty would not be administered in a capricious or discriminatory manner. Over time, the courts have also interpreted the Eighth Amendment as requiring that executions be carried out in the most humane and least painful manner. Public discourse and debate have strongly influenced thinking about which methods of execution are appropriate. Recent studies, however, suggest that states' administration of the sedative sodium pentothal has left individuals conscious and in agony, but paralyzed and thus unable to cry out while they are dying. But in 2008, the Supreme Court ruled in a 7-2 decision that lethal injection does not constitute cruel and unusual punishment, paving the way for 10 states, which had halted lethal injections pending the case's outcome, to resume executions. The 2008 decision of Bays v. Reese marked the first time the Supreme Court reviewed the constitutionality of a method of execution since 1878, when the court upheld Utah's use of a firing squad. In that early ruling, the court said the Constitution prohibits executions that involve torture, such as burning alive or drawing and quartering an individual, as well as other infliction of unnecessary cruelty that the justices did not define. As you can see in this map, states have greatly differed in their interpretation of a constitutionally legitimate means of execution. In the recent case, lawyers for the Kentucky inmates argued that the state is violating that standard by using drugs that pose a risk of extreme pain if something goes wrong and by failing to provide adequate safeguards. But in its decision in 2008, the court ruled that there is no Eighth Amendment requirement that a government-sanctioned execution be pain-free, only that it does not involve a substantial or objectively intolerable risk of serious harm, a risk greater than possible alternatives.